Hello everyone and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education commentary, and today is the day that we earn that subscription. For today's story, we're going to do something really short because we're going through the Trump search warrant that was just released, and it basically says what I told you it would say, which is a whole lot of nothing. But we're going to cover it anyway because, why not? So here's a copy of what they've released. First of all, we've got a notice of redacted documents. The United States hereby gives notice that's following the following document, which is a redacted version of material previously filed in this case under seal, namely the search warrant, not including the affidavit, which is what we really care about. The search warrant will tell us what. The affidavit tells us why. The what is not that interesting because the what is very, very predictable. In fact, I did predict it almost verbatim, because it's not that hard to predict. The why is much more interesting. Like, why are we doing these things? Okay. So anyways, we got a copy of the search warrant, not including the affidavit, signed and approved by the court, and the property receipt. Okay, that's great. So here's a copy of a search warrant. Here's what one looks like. Of course, states follow their own format, but this is what the federal format looks like. And states often are similar in their format, but not uniformly. So here's what we got, right? So what is it? Well, what does a search warrant need to have? Okay, Fourth Amendment says, in order to have a search warrant, we need to state the place or persons to be searched or seized with particularity, and we need to do so with a sworn affidavit. Okay, so we need to state where we're looking and what we're seizing. Fine, so let's do that. So it's in the Southern District of Florida because that's where Mar-a-Lago is. In the matter of the search of the premises located at 1100 South Ocean Boulevard, which is Mar-a-Lago. We have to give the address of the place to be searched with particularity. Okay, fine. 2, any authorized law enforcement officer. An application by a federal law enforcement officer or an attorney for the government requests a search of the person or property located in the Southern District of Florida as described by the street address above. Namely, let's see attachment A. I find the affidavits or record testimony establish probable cause to seize whatever. See attachment B. Okay, you're commanded to execute this warrant on or before August the 19th in the daytime. Fine. You must give a copy of the warrant and receipt for property taken to the person from whom or from where the premises was taken, or leave a copy and receipt at the place from where property was taken. Yes, surprising absolutely no one. The person getting the search warrant gets a copy of the search warrant, not the affidavit, but they get a copy of the search warrant and a receipt for their property. Sure. So you have to leave them a copy because they're entitled to that by law. The officer executing this warrant or officer present during the execution of the warrant must prepare an inventory as required and return that to the magistrate. Signed, magistrate. Fine. What is the thing to be searched? Well, the premises to be searched at 1100 South Ocean Boulevard is further described as a resort club and residence located near the intersection of South Boulevard and South Ocean Boulevard. It's described as a mansion with approximately 58 bedrooms, 33 bathrooms on a 17-acre estate. I'm not sure that they're going to miss it. I think they can figure it out. The locations to be searched include the 45 office, all storage rooms, and all other rooms or areas within the premises used or available to be used by the former president and his staff. Yeah, basically what I told you, right? We're going to search everywhere the president is or can access all his spaces, right? And in which boxes or documents could be stored, including all structures or buildings on the estate. It does not include areas currently, that is, at the time of search, being occupied, rented, or used by third parties. Not that it normally would, right? That's typical for a search warrant. That would apply in a person's home typically as well. If a room is used exclusively, or a portion of a building, or a building, or whatever, like if it's used completely by someone else entirely, then that's their property. Right? So if you come to search my house and I rent a room to somebody and that's their room, the search warrant doesn't extend to their room because it's their room. Unless of course the warrant gives probable cause to believe it's in that room. But this is very typical. So yes, of course, it doesn't extend to any property that's used by third parties exclusively and not used or available to be used by the former president, such as guest suites. Unsurprisingly, right? We get to look everywhere the former president has access to, him and his staff, and we don't get to look anywhere that he doesn't have access to, which would include, among other places, things that are being rented out entirely by someone else, because it's not his property then. It's being leased. All right, so attachment B. What are we looking for at Mar-a-Lago in all the rooms? Well, we're looking for all physical documents and records constituting evidence, contraband, fruits of crimes, or other items illegally possessed in violation of law, including the following specific documents, including the following specific things. Any physical documents with classification markings, along with any containers, boxes, including any other contents in which such documents are located, as well as any other containers, boxes that are collectively stored or found together with the aforementioned documents and boxes. So we get to take the documents and any boxes that they're stored in and any boxes that are stored with, because those boxes may also contain things that are marked classified. Now, I will take a note here that just because they're marked classified doesn't mean that they are classified, right? Because we've discussed this, at least a little in part, right? Because it's the President of the United States. The President of the United States has unilateral, plenary, unchecked power to declassify anything at any time on a whim. So, just because they're marked classified doesn't mean that they are classified. But they might be classified, and all we need is probable cause. And if they're marked as classified, well, that's probable cause to believe that they are classified. But whether or not they are classified is a whole nother legal issue that's going to have to be decided at some point down the line, maybe. But sure, on a probable cause standard, sure, why not? Information, including communications in any form, regarding the retrieval, storage, and transmission of national defense information or classified material. Okay. Fine. That's pattern and practices. Fine. Any government and or presidential records created between January 20th, 2017 and January the 20th, 2021, that'd be during the time he was president. Now, I will take note here that at least my understanding of the Presidential Records Act gives the president 5 years to turn over documents to the National Archives, and he hasn't not been president for 5 years yet. So I'm not sure that even if they are presidential records within the meaning of the Presidential Records Act, and they do belong to the National Archives, that he's necessarily obligated to turn them over at this time. Because I think he gets 5 years. But I'm not an expert on such things. But anyways, we're looking for those. And any evidence of knowing alteration, destruction, or concealment of any government record or presidential records or any other document with a classified marking. So anything that might show it's been edited, revised, intended to be deleted, hidden, whatever, right? So this is pretty much exactly what I predicted, almost word for word, because it wasn't very hard to predict, right? It's like, what is the search warrant going to say without even reading it? Well, it's going to give you the location to be searched, Mar-a-Lago. Where are we going to be able to search? Anywhere the president has access to. Anything that might contain the documents. What are we going to take? Anything that looks like a governmental document. So, very not exciting and extremely predictable. But, that's fine. And what did we take? Well, not a lot of information that's going to be helpful. We took some documents, and we took a whole bunch of boxes that are labeled various things. And then we took an executive grant of clemency regarding Roger Stone, which I'm not sure how that's responsive to any of those things, but whatever. Information regarding the president of France. Sure. Leather-bound box of documents, various classified documents. Now, again, this is prima facie. They might be marked classified. Are they classified? Is a question we don't know the answer to. Because the president has absolute unilateral, plenary, complete, unchecked authority to declassify anything at any time for any reason on a whim. So, are they classified or not is not a known question at this time. Incidentally, this is power that belongs uniquely to the president. So if you're thinking to yourself, wait a second, when it came to Hillary Clinton, we didn't do that. You're right, because Hillary Clinton wasn't the president. Hillary Clinton, as Secretary of State, doesn't have the power to just unilaterally declassify anything at any time for any reason. She has to go through a process. The president doesn't. So the fact that it's marked classified, it's marked TS-SCI, well, is it? I don't know. It might be. It might not. We might have to get into it later. Potential presidential records, binders of photos, a handwritten note. Now, apparently, this is the handwritten note that Obama left Trump, which is very typical. I don't know whether or not Trump left a letter for Biden, but it's very, very typical. The outgoing president leaves a letter for the incoming president. It's kind of standard fare. So Obama left Trump a letter, and they're taking the letter? That's mean. That's just mean. I don't even know if that qualifies as a presidential record. I guess it kind of does, but damn. Boxes, miscellaneous secret documents, miscellaneous top secret documents, miscellaneous top secret, miscellaneous confidential documents, some boxes, confidential documents, and blah, blah, blah. So we don't know anything. So we have no information about this particular things taken, except we've taken a whole bunch of boxes of documents that may or may not contain governmental records, because remember from the search warrant, they just had to be boxes adjacent to boxes that held classified information. That's what the search warrant said. We get to take the documents and the boxes that they're in and any boxes they happen to be near at the time. So it's not necessarily even clear that all these boxes contain any classified information, or that they even superficially contain any classified information, because the search warrant said take anything that's even remotely close, because maybe they contain classified materials, maybe. And so we're going through that. And without the affidavit, though, it's impossible to analyze anything. The affidavit is what you really want, because the affidavit gives you the why, right? The search warrant gives you the what. The search warrant is entirely predictable. And what the inventory of records is entirely predictable. Nothing about this surprises me. It shouldn't surprise you either. What would be surprising, or at least would be informative, if not surprising, would be the affidavit. The affidavit would tell you why. The affidavit would give you a list of sources. The affidavit would give you a list of evidence. The affidavit would give you a list of reasons. It would give you more specificity. Right? The search warrant doesn't have to give you more. The affidavit usually gives you a lot more information. We'll never see the affidavit, possibly ever. The Attorney General has said we're not going to see it. He said he's not allowed to share it with us. First of all, yes, he is. He's the Attorney General. So yes, he can. He's not going to, because it will prejudice his investigation, assuming there is one of any merit. But he could. And maybe he will. Maybe he'll change his mind. You know, circa 2024, when there's a ramp up to an election. Maybe he'll change his mind in September or October of 2024, if you want to forecast 2 years into the future. Or maybe some other opportune moment when it'll be like, yeah, maybe now's the time to reevaluate whether or not I should release that. And smear the former president, depending on whether or not he runs for re-election, is the candidate, gets nominated, so forth and so on. So they're going to hold that in reserve for some future time, I'm sure. Susan Swenson gave me $5 of a lemon sitting on a chair with sunglasses waving at me. The lemon brightens my day. Thank you, Susan. And he gives me $5. Anything to the theory that TSI, CSI documents classified by statute can't be declassified for POTUS because the executive branch is not the originating authority. No. First of all, who else would be who else would be the originating authority? I'm not sure that anything can be classified except by the executive branch. Who else would be classifying stuff except by the executive branch? I mean, I'm thinking in the back of my head, I think the only thing that even comes close would be, it's not really classified, I don't think, would be the opinions of the FISA court, maybe. I don't know whether or not they're considered classified or not, or they're just not published or not, but pretty much everything is classified. It comes from the executive branch. I'm trying to think what can be classified that doesn't come from the executive branch in some way. So I don't even know what could theoretically be classified that doesn't come from the executive branch. What would that be? You know, it all comes from the executive branch. Yeah, it doesn't quite make sense. Court documents aren't typically classified. They're secret. They're not exactly classified. They're under seal, but that's different. Right? They're not classified. They're under seal. And the executive doesn't have access to them anyway because they're under seal. Right? So if you're thinking about documents, so the executive can't release them because they don't have them in the first place. So documents that are kept under seal by the judicial branch are kept under seal by the judicial branch. So the executive can't release them because they don't have them. So they couldn't declassify them either in fact or in law because they don't have them in the first place. So judicial documents are sealed by the judicial branch. Documents held by the legislative, if there are such things, are kept by the legislative. So the executive branch can't declassify them, assuming they were classified, or release them because they don't have them in the first place. The executive branch could only possibly release things that are within the context of the executive branch. So I'm not sure there is such documents. I think pretty much everything that's classified is executive branch. The Department of Energy is part of the executive branch. The military is part of the executive branch. The NSA, CIA, FBI, and the rest of the national security apparatus are all executive branch. It's executive branch pretty much all the way down. So, And documents under legal seal would be kept by the judicial branch. So the executive wouldn't have them to release them in the first place. So that wouldn't, I'm not sure that makes any sense. Why did Obama take documents home? I couldn't speak to that issue. I can't speak to I also can't speak to the issue of why Trump took those documents home. I also can't speak to the issue of whether or not Obama was entitled to keep those documents at home or not. I don't know. I haven't looked at the specifics. So I couldn't begin to answer those questions for Obama. Maybe he's entitled to have all those documents in his house. I don't know. I don't know whether or not they're subject to Presidential Records Act or not, or whether they're personal records, or whether anything. I don't know. I'm not sure. Scientific research and inventions can be required to be classified. This is true, to some degree. Inventions can be classified. They're not classified by the Patent Office. They're classified by other agencies. But the Patent Office does deal with secret patents or patents subject to secrecy orders. But the Patent Office, the secrecy orders are issued by the executive branch. So it's usually, although not exclusively, like military. Naval research, for example, does a lot of classified work. Well, there's not that many classified patents. There are not that many of them. But there's maybe 1,000 of them sitting out there. But, for the 1,000 or so that exist in various stages of classification, yes. But and then also you have the idea of born secret. For example, for certain atomic nuclear secrets, there's it's been a while since I read the relevant statute, but certain nuclear stuff is born secret, so it doesn't have to be classified by the classification agency. The moment it's created, it's automatically classified by operation of law. It's called born secret. So I know about that. But even there, it can be declassified by the executive, because if you're talking about, for example, nuclear secrets, right, that's the Department of Energy, which is an executive branch agency. So there's that. Do I think it's political? I think it's unavoidably political. Whether or not there's any legal basis to this is hard to say. I'd have a lot better basis to answer that question with an affidavit, because that would give me a lot better basis to understand the laws that they think are in play and the probable cause for their beliefs. So without the affidavit, it's a little bit hard to say, but it's unavoidably political, because there are obviously political repercussions, not only to the immediate issues, but also to what future administrations will do. Because now that you've broken this barrier, you've opened Pandora's box of searching a future president's home. What does a future Republican administration do? right? So there are unavoidably political repercussions. Is this itself political? I mean, to some degree, yes, unavoidably so. Does that mean that Trump broke the law or not? I don't know. Does it mean Obama broke the law or not? I don't know. But you didn't see the Trump administration searching the home of Obama for 30 million documents. So I'm just saying. Yeah. So the president can declassify all the secrets. Yep. Correct. Yeah, he can declassify everything instantly. He doesn't have to go through any process, and he can classify things, I think, instantly too, because he has absolute unchecked classification authority. It's one of the perks of being president of the United States. Yeah. It is unavoidable how disrespectful this has been. Yeah. If this turns on small things. And also, by the way, although like from a pure legal standpoint, it doesn't necessarily matter. I will just point out that from a practical matter, not everything that's classified secret or top secret is necessarily that interesting or even that damaging. That isn't to say, of course, that everything isn't. But there has been a bit of a trend, although the United States has been trying to reverse this to some degree, of overclassification and things being classified that shouldn't be. And sometimes things are declassified. And at least when I read them, I'm like, why was this ever classified in the first place? So some of this might be, of that ilk. So the degree to which it should have been classified in the first place is at least an item of note in this entire equation. So if this comes down to, a what you might consider a technical violation of the law, that's going to be one thing versus something more than that. The current president could reclassify them in the defense as moot. Well, he'd have to know that. He'd have to know that. I mean, he'd have to know that he's in possession of materials he's not allowed to have. And so yeah, because you can't just innocently expose someone to criminal liability, right? You can't. Your ability to reclassify them is one thing, but if you do, you can't just reclassify them and be like, oh, now you're in possession of classified materials that you're not allowed to have. That's not fair. You can't just like basically speak into existence a criminal violation. That doesn't quite work. Tim West says, I didn't do it, but if I did, it doesn't matter. They weren't important. I was simply taking note, Tim, that that just because something is TS CSI doesn't necessarily imply it's important. Because every once in a while things get declassified. At least I wonder why. So I'm just taking note that the nature of the exposure is not necessarily a given. That doesn't necessarily imply a legal determination. I was just taking note because I thought it was an interesting thing to comment on. Batman Pet Goldfish gives $2. Says, watch it be his schedule for the last day. Cute. A judge did approve this, yes. A federal magistrate judge approved this, yes. I don't think it wasn't a judge appointed by Trump because it's a magistrate judge. So it wasn't appointed by the president at all. Magistrate judges get appointed usually from the district courts, unless I'm horribly mistaken. Magistrate judges are not Article 3 judges. They're appointed for terms. And I forget, are they nominated by the president? I actually forget the exact process. It's been a while. It is very political, yeah. Let me look it up while I'm here, see if I'm okay. Let's see. Federal. Are they? Let's see. Magistrate judge. Yeah, magistrate judges are appointed by a majority vote of federal district judges. That's what I thought. Yeah, so they're not nominated by the president and confirmed by the Senate. They're nominated by the courts and confirmed by the courts. Yeah, so it can't be a Trump appointed judge because it wasn't a president appointed judge at all. It's a magistrate judge. Blue Run Vegan says he had to identify the specific documents he's declassifying. He needed to memorialize the order in writing for bureaucratic historical purposes. They need to have staff physically. I doubt that very much. I doubt that very much to be true. And you can prove it's not true by thinking through the reasons why the president could declassify things in the first place. So, like, you know, the president is head of state. So let's suppose the United States has been involved. I'll prove it's not true by way of example. Suppose the United States has been involved in a clandestine operation overseas that has gone sour, right? And now the ambassador from that country is now standing in the Oval Office demanding answers, right? So the president, as head of state, might want to, could go a couple different ways in solving this problem. But one of the things he might do, or he could consider doing, is revealing the truth of it, right? It's like, maybe if I reveal the truth of it, maybe that will get me some credibility. So the president needs the ability to do that. So you're telling me that in order to tell the ambassador, because this is classified information, right? It's a clandestine operation. That was the premise of the hypothetical, right? So it's a classified operation. You're telling me that in order for the president of the United States to reveal this information to the ambassador, he has to write a memo? I don't think so. I think he can just do it. I think he can just literally hand the information regarding the top secret plans, and he can just hand it to the ambassador and be like, here's the top secret plans, are bad. So I don't really think he has to write a memo. And nor necessarily speak any particular words into existence. I don't think he needs to say anything. The ambassador comes in and says, I demand answers, and he just hands him the folder. You don't think the president of the United States can do that? I think he can. You know? I'm going to take this out and I'm going to go talk to the press. The president can't do that? I think he can. I really don't think the president of the United States has to follow any secret formula, handshakes. There doesn't have to be a memo. He doesn't have to mark it in any way. He can just do it instantly on a whim by word, deed, action, or any other method that will please his fancy. Because he has absolute, unchecked, plenary, complete authority of declassification. Can the affidavit be FOIA'd? No, unfortunately, it can't, because the affidavit would not be FOIAble due to several exemptions and exclusions in FOIA, relating to specifically the fact that it's an ongoing investigation. So, no, FOIA is out of the question, but, you know, the Attorney General said he can't unseal it. He totally can. He totally can. And who's he going to write to? Himself? Yeah, exactly. The president's declassification memos go to the DCI. The DCI works for the president of the United States. I mean, he can send a memo to the DCI. He can send a memo to the DCI, but does he have to? No. That's not a necessary process. It can't be. It can't be, because the DCI works for the president. So it can't be a necessary process. It might be helpful to tell the DCI about it. That might be a nice thing to do, but is it legally required? No, not for the president. The president's the head of the food chain. There's nowhere left to go. If he tells the DCI, he's just telling himself. You know, because he's the president of the United States. He's not king. There are rules he has to follow. This is true. You're absolutely correct. The president is not king. You are absolutely correct. The president cannot do just anything he wants at any time. But this is what we call plenary authority, right? So the idea, by the way, all branches of government have plenary authority in limited circumstances, but they do. Like, for example, I'll give you plenary authority from other branches. Like, it's plenary authority of the Congress to throw out a member. It's unchecked power. No one can stop them. No one can review it. It's plenary authority of the legislative branch to impeach a governmental official. It's unreviewable. It's unchecked. It's absolute. It's unquestioned. It's in the Constitution. All right? Unchecked, absolute, total power. No one can stop them. All right? Plenary authority. And the Constitution and at least the judicial branch says it has plenary authority to interpret the Constitution. Marbury versus Madison, most famously, right? Let's see if I can get this word perfect. I can't quite get it word perfect. It is undeniably the duty of the judicial department to say what the law is. It's close. But basically, the judicial branch itself says it has plenary authority to interpret the Constitution. And no one can check them. Right? Absolute, unquestioned power. Right? And so, yeah, the president is not king, but the Constitution does give him some unchecked, unquestioned power. For example, the power to pardon is such a power. The president has absolute, unchecked, unquestioned, unreviewable power to pardon. No one can stop him. No one can limit him. He can pardon anybody. For federal crimes, of course, not state crimes. I mean, he's limited in that way. He can only pardon for offenses against the United States, so he's got that going for him, but still. So yes, and this is another example of plenary authority. The president has plenary authority to declassify. So, he's not a king. He doesn't have all power, but he does have this power that's unquestioned. And there's checks and balances, but some powers are unchecked and unbalanced. This would be an example. It also, by the way, derives at least in part from his authority to be commander-in-chief of the armed forces. So, and there's Supreme Court case law on point as well. Also, the fact that the Constitution says the executive power shall be held by the President of the United States, namely all of it. So the President of the United States has all the executive power, all of it, because that's what the Constitution says. So all the other executive agencies and all the other executive officials are merely his agents. They're all fractions of his power. Like the entire executive branch, including the military, incidentally. Right? This is the principle of Article 2. Right? All the executive power belongs to the president, full stop. So that means that all the executive officials, all 2 million of them, right, including the military, including the cabinet, including every federal bureaucrat, are all just fractions of power he had in the first place, right? They all are pieces of him or her, as if we ever elect a female, right? So the president can do anything any of those people can do because they're all just fractions of his power. He's the principal. They're all his agents, right? That's the nature of agency. An agent can only do what the principal can do. The principal has all the power in the first place. So the principal can do anything the agent can do. So the President of the United States can do anything that any executive branch official can do, because they all are derivatives of his power, at least in principle. That's the idea. That's what the Constitution seems to suggest. So he has all the executive power. That's a lot. It's not legislative power. It's not judicial power, but it's all the executive power. So, it's fun. Can the president mandate the IRS have a maximum of 1 employee? Well, no, not necessarily, because Congress can create a federal bureaucracy, but they all have to obey his orders. He can give an order to the IRS commissioner, who has to follow it, and then his subordinates have to follow, and so forth and so Daryl B says, Kurt, did you happen to see Dan Bogino's interview with a former FBI agent that's now a defense attorney on how they quote unquote got a CHI? I did not see that interview, but thank you for bringing it to my attention. So what? So the president can bring charges in the same way the attorney general can? Yeah, at least in principle. Sure. Right, because the attorney general works for the president. The attorney general is the president's agent. The president can fire the attorney general. The president can appoint the attorney general. The president can command the attorney general. Yep. And that's, yep. Yeah. Richard says, his authority to classify and control access to information bearing on national security flows primarily from the Constitutional Investment Authority. Yeah, you got it. That's all right. It's constitutional principles. So what's the legal remedy or resolution in this situation? I have no idea. I'm nowhere even close to being able to analyze what the illegal exposure is for Trump. Nowhere close to being able to analyze what legal exposure, if any, he has. It's not all clear. And I have no basis to know at this time whether or not the degree to which the solidity of the search was, because I don't have access to the affidavit. I simply don't know. YouTube turns out tens of thousands of legal scholars each year. That's okay. That's why we're here to help. We're here to give a good quality legal education. Right? People say things, I'm like, yeah, that's not true. Here's what's true. Here's the principles here's the principles that apply. But we're getting better. That's one of the reasons we have LawTube, to help people learn. Why has Trump not disclosed the affidavit? He doesn't have it. He doesn't have the affidavit. He has the search warrant and he has the inventory. So the DOJ in some sense released things that were already out in the open, at least in principle. Right? They released a copy of the search warrant and the inventory, but Trump already had it. So it wasn't a secret. So they made something public that Trump could have released at any time anyway. So I was like, Can they continue to conceal the affidavit and leave everything in limbo? Yes, and I'm pretty sure that's the most likely outcome. I think that's the most likely outcome. I think the most likely outcome is limbo, with perhaps occasional rumblings of something. The only time I really see anything happening is if Trump gets nominated as the Republican nominee. And then maybe you're looking to have a release in 2024. So mark your calendars for 2 years from now. So I think this, I don't think, you might hear rumblings, but you're not really going to see anything of note for some time. So, yeah. Trump had, assuming the documents are classified, which is one hell of an assumption. Assuming documents are classified, Trump had every right to those documents until the moment he stopped being president, which was January the 20th of 2021. And the statute of limitations is 5 years. So that means the clock, assuming it exists at all, the clock started running on the statute of limitations on January the 20th of 2021 at noon, which means that the federal government has until 2026 to indict him if they want to. So no rush. I don't think you're going to see anything publicly unless Trump runs, gets nominated. Maybe if he gets nominated, maybe you see some rumblings, some light leaks. But I don't think you get a copy of the affidavit until he wins the nomination. And they need like that October surprise. So fast forward 2 years from now, and maybe you'll get the affidavit then. Can Trump's lawyers get access to the affidavit? No. No, they can't. And Trump can run and serve as president from prison. Although, if he wins, he can just pardon himself. because the crimes in question are federal, which is hilarious. So Trump can run because the Constitution itself sets out the requirements to be president. In order to be president, you have to be 35 years of age, you have to be a natural born citizen of the United States, and you have to have lived in the United States for the last 10 years. Last time I checked, Trump met all those criteria. So that means up to and including him being indicted, charged, convicted, and being sent to prison, he can run for president. Which means that if he wins as president, he can just pardon himself and just let himself out of prison, which is hilarious. So this is the world we live in, man. It's a strange world. Doesn't the warrant specify some of the documents are secret? The warrant said they were looking for secret documents, and the record of the property says they seized documents marked as secret. But them being marked secret and them being secret are not quite the same thing, because again, it's President Trump, and so you have to ask questions you wouldn't normally ask in any other context, right? If this was Hillary Rodham Clinton, you wouldn't be asking these questions because Hillary Rodham Clinton wasn't the president. If you were talking about Obama with his 30 million documents, you'd be asking the same questions. So like for Obama, you ask the exact same questions. Like that's one of the reasons I'm like, I don't know. Maybe he took 30 million documents home. Maybe he was entitled to those documents. Maybe they're presidential records, maybe not. Maybe he declassified them all. I don't know. Because when it comes to Obama, I have to ask the same questions because Obama was president. So you now have to ask questions you wouldn't normally have to ask in any other context. Like, well, they're marked TSI, CSI, or SCI. They're marked TS, SCI. But are they? I mean, there's no memo anywhere that says they're not, and there's no like documentation that says they're not, but are they? Right? So you run into this weird question that you wouldn't normally have to ask any other time. Because it's President Trump or President Obama, as the case may be. Aren't there state laws in some state that prevent felons from appearing on the ballot? To the extent that such laws would apply to the President of the United States, they're constitutionally invalid. It may well be true that felons cannot appear on the ballot for any office other than President and Vice President. Fine, or actually members of Congress for that matter. Because I don't think they can be excluded either for the same reason. But if it's any state level official, sure, you can keep state level officials off the ballot for being felons. But to the extent that you are trying to keep any federal official off the ballot, the hypothetical is a state has a law that prevents felons from being on the ballot, but these are federal offices. And you know how that usually works, right? So you have a federal office, and now suddenly you're asking like a question like, okay, there's a state somewhere that says felons can't appear on a ballot. So you have a state law trying to apply to a federal office. Yeah, how well does that work out? Not well, right? Because now you have a conflict. And supremacy clause, U.S. Constitution wins. So to the extent that any such laws exist, and to the extent they would try to prevent any felon from running for federal office, it's constitutionally invalid. It'd be valid for state level officials, that's fine. States can impose any requirements on their state level officials they want, that's fine. But states cannot impose requirements on the federal offices. See, for example, U.S. Term Limits, Inc. Supreme Court case. Great case, by the way, dealing with whether or not term limits were constitutional. They're not. But that would be a good authority for that proposition. Pam Ronning gives $9.99 just because. Well, thank you, Pam. I do appreciate it. That's wonderful. Yeah. Yeah. Fred Sharp says it right. The president has plenary power to declassify. That means Congress cannot burn his authority, including declassification procedures. Correct. Absolutely true. To the extent the president has authority that derives from Article 2 inherently, Congress can't limit it. It'd be like Congress trying to pass a law that limits the president's ability to pardon. Nope. Nope. Can't do that. can't do that. Yeah. Top secret documents recovered. AOL claims this is a serious crime. It might be. It might be a serious crime. I don't know. Because we're having to ask questions we wouldn't normally ask. They might be marked top secret, but are they is now a question that is weird. Yeah, constitutionally, the states are set to limit time, place, manner of elections. You got it. Yeah, and they cannot impose additional requirements. I think it was Thornton versus U.S. term limits, I believe was the name of the case. From Alabama or Mississippi, try to impose term limits on officials. Incidentally, as memory serves, the relevant law at the time in Mississippi or Alabama was not that they couldn't run, just that they couldn't be on the ballot. So they could be written in. So the way they try to get around this by saying, oh, we're not saying that they can't win. We're just saying we're not going to print their name on the ballot, right? So they could still win by a write-in vote. But they couldn't appear on the ballot. The U.S. Supreme Court said that was too much. That was U.S. term limits versus Thornton. Great case. You can't put additional requirements in order to be a senator, a representative, or president or vice president, because the requirements for those positions are set up by the Constitution. So, yeah. Or I suppose a federal judge anyway. Not that would make sense, because you don't run for federal judge. You get nominated by the Supreme Court. You get nominated by the president and confirmed by the Senate. So, you can be a felon. That's fine. If you can get the Senate to vote for you. Didn't Colorado try to pass a law saying presidential candidates couldn't be on the ballot if they didn't reveal their finances? Yes. And California did as well. California, well, I don't know about Colorado, but I can tell you California did. California passed a law that said presidential candidates can't appear on the ballot unless they reveal their finances. Trump took that law to court. The California Supreme Court struck it down for exactly this reason. So yeah, California did. California absolutely passed a law that said, yeah, to be on the ballot, you have to give us your tax returns. Trump said, no, I'm going to sue you. The California Supreme Court said, can't do that. Unconstitutional. So yeah, we've been down this road at least partially already. High crimes and misdemeanors has to mean something legally? Sure it does. It just means whatever Congress wants it to mean. Because the question as always on these issues is who gets to decide, right? The question as always is who gets to decide. Well, in the case of impeachment authority, when it talks about high crimes and misdemeanors, who gets to decide? Oh, that's easy. I know the answer to that. The Constitution tells me the House has the sole power to impeach, and the Senate has the sole power to try all impeachments. So who gets to decide? The House and Senate. End of analysis. Because that's what sole means, right? If the House has the sole power to impeach, and the Senate has the sole power to try all impeachments, well, that's that. So yeah, high crimes and misdemeanors mean something. What does it mean? Ask the judge. Who's the judge? The United States Senate is. It means whatever Congress wants it to mean. Because they're the ones that get to decide, because the Constitution says they do. Then there's no appeal. There's no appeal possible, because that's what sole power means. It's what we call in law a political question. It's something that's wholly devoted. It's something that's wholly devoted to one of the political apparatuses. In this case, the Congress. House has the sole power to impeach. Senate has the sole power to try. Sole means sole. That means that the U.S. courts are without jurisdiction. There is no possible review in federal court. Go away. Yeah. The Atomic Energy Act of 1954 does not defeat the Constitution. Absolutely true. Right. No act of Congress can take away inherent power of the presidency. Right. For all you law students out there, this is Youngtown Steel. which hopefully will strike a bit of a chord among the law students out there who have taken their constitutional law. This is Youngstown Steel, right? When the president is acting in concert with when the president is acting in concert with Congress, when the president is acting silently, and when the president is acting against Congress, right? There are three tiers of possibilities, right? So, like, the president is acting in concert with Congress, the president's power is at its absolute zenith, right? If it's acting silently, we're kind of in some middle ground, and the president is acting against Congress, acting against the statute, then it's whatever residual inherent power of the presidency must emerge. Youngstown Steel, baby, for the win. Holla. You barely remember that? See? Man, you never know when these things are going to be useful, man. Amy says, I've been ICU nurse for 22 years and can't remember everything. It amazes me how you're able to recall law cases and constitutional law just at the top of your head so quickly. I love this shit, though, so much. I love it so much. So much fun. An amendment? Yeah. CG, an amendment? Yeah. People always ask, what about a constitutional amendment? Yeah, a constitutional amendment's a nuclear bomb. Okay? A constitutional amendment can do anything you want to do. All right, except of course change the equal representation of the states among the Senate. So if you want to do anything other, then change the equal representation of the states in the Senate. So if you want to just arbitrarily say that Delaware only gets one senator, you can't pass a constitutional amendment for that. Anything else you want to do, you can have a constitutional amendment for that. Constitutional amendment's like a nuclear bomb. It can do anything you want to do. It's magic. So if your question is, can a constitutional amendment do this? The answer is pretty much yes. Except for the, take a seat away from Delaware for no particular reason. Unless Delaware says yes. Delaware has to say yes. So you can't change the equal representation of the Senate unless the state that's being infringed against says okay, which why would they? But there's your exceptions to exceptions to exceptions for the day. Yeah. What's the point of the Chief Justice being there? Oh, that's easy. That's easy. What's the point of the Chief Justice being there when the president is being impeached? You should know this one without me telling you. You should know this one without me telling you. What is the reason for the Chief Justice being there to preside over the trial if the President of the United States is being impeached? Well, I'll give you a hint. Who else would be presiding over the trial of the impeachment? I'll give you a clue. The normal person that would be presiding over the trial of an impeachment is the President of the Senate. Okay, pop quiz hot shot. Who is the President of the Senate? So why is the Chief Justice the one that's presiding? Well, because the alternative person who would preside over the Senate is the President of the Senate. Okay, who is the President of the Senate? I know you know this one. I know you've got it in you. The VP. There you go. The Vice President is the President of the Senate. So why is the Chief Justice the one presiding? Because the person who would otherwise be presiding is the Vice President. Why would we not want the Vice President to preside over a trial to determine whether or not the President gets removed? Oh, I don't know. Let me think about it for half a second. So we had to come up with someone else. So we made it the Chief Justice. That's why. Duma says, thanks for making legal education practical and enjoyable. No problem. You're welcome. Yeah. Particularly, by the way, because this provision was written at the time prior to the 12th Amendment. Yeah, this is the 12th Amendment, right? That changed the vice presidency. Because as some of you history buffs may know, originally, the vice president was not independently elected, right? There didn't used to be a position on the ballot for president and vice president, right? Originally, the vice president of the United States was the runner-up of the presidential election before the 12th Amendment. Right? So there was no election for the position of vice president. There was just an election for the position of president. Number one became president. Number two became VP. So this would be the equivalent in the last election of Hillary Clinton being the vice president for Donald Trump. Because that's what the Constitution used to provide for. Right? So Hillary Clinton would have been the vice president while Donald Trump was in office. Okay, so ask yourself the question again, why are we trying to prevent the vice president from being the one who's going to be the chair and presiding officer over the trial to determine whether or not the president should get removed? Oh, I don't know. Why might we not want Hillary Clinton to be the person who's going to decide whether or not President Trump is guilty or not? I can't think of any potential reasons. So we had to come up with someone else. So we came up with the Chief Justice. There, and we didn't bother to change that provision when we made it so that, you know, and maybe we'll have it as a ticket. So maybe it's not the runner-up who's the vice president. Maybe it's someone else. But we didn't bother to change that provision in the Constitution, so it's legacy. There you go. This is all fun and history. It's good times. Cargo pilot guy said 499. The Constitutional Convention will happen. States stopped passing amendment when limiting judges took hold through the 20th century. I am extremely nervous about the Constitutional Convention. I don't know whether or not it will happen or not, but I am incredibly, incredibly nervous about a Constitutional Convention because I think it's going to go to shit. I could be wrong, and God hopes I am, but I think it's going to go to shit. I think the Constitutional Convention, if it ever happens, is going to come up with all kinds of wacky, crazy shit. And not for the better. Now, I suppose I can be slightly encouraged by the fact that I need 3/4 of the state to still ratify whatever bullshit the Constitutional Convention comes up with. So I still need 38 states, I think. Is that 3/4? I think so. I still need 38 states to sign off on whatever bullshit the Constitutional Convention comes up with. But I think if a Constitutional Convention ever happens, it's going to go to hell, and God only knows what happens next. So I'm very scared. I'm scared. Hold me. Chances they'll repeal the Commerce Clause? Maybe we could just limit it to actual interstate commerce. That'd be a nice start. How about the Interstate Commerce Clause only applied to actual interstate commerce? Here's an idea. Here's a fun one. What if interstate commerce applied to interstate commerce? Whoa, I know. What if the Interstate Commerce Clause didn't apply to the non-interstate non-commerce? I think that interstate commerce applying to non-interstate non-commerce is probably not what the Interstate Commerce Clause had in mind. I think when they wrote the Interstate Commerce Clause, they probably did not contemplate the Interstate Commerce Clause regulating the non-interstate non-commerce. Just a personal conceit. So how about we just limit the Interstate Commerce Clause to actual interstate commerce? That'd be great. Ask me about Wickard v. Filbert, right? Good times. What else can I answer for you since I got 580 of you having here and I'm a lot of fun for you? That's a lot excuse for a lot of gun laws, interstate commerce. That's the excuse for a lot of the federal laws, just period. And it's all based on Wickard v. Filburn. It's all Wickard v. Filburn all the way down. Because the Interstate Commerce Clause gives me the power to regulate non-interstate non-commerce. So when you have a constitutional provision that apparently includes its exact opposite, you know, that's a thing that apparently exists. I'm not sure how, but it does. So Thoughts on the repeal of direct election in senators? You'll never get that. You won't even get that from convention of states. You'll never get the people to vote for that. They're not going to repeal the 19th Amendment. Are you out of your mind? Wait, is that 19th? 17th Amendment. Sorry. 19th is the woman's vote. Apologize. You'll never get them to repeal the 17th Amendment. Are you out of your mind? You won't also get them to repeal the 19th Amendment. You won't get them to do that either. Either one. That's a piece of merch. Ask me about Wicked v. Filbert. Should be a piece of merch for sure. It's like the very old legal joke. It's the very old joke that it was a man show skit one time. It's like, we don't like to see women suffering, so end women's suffrage now. And you got women to sign off on a petition to end women's suffrage. Wow, yeah, that was an old skit. They got the man show boy to go around and get women to sign a petition to end women's suffrage. It's like, well, women's suffering is bad. Let's get them to end suffrage. Wow. Ask me about Wicker v. Filburn as a monk. I respect that. Dawkins says, I got through my YouTube feed and see search warrant unsealed, and then breaking Trump releases that release document. Then I see Trump search warrant tells us nothing. I love this channel. I just tell you like it is. It tells you nothing because I told you what the search warrant said yesterday. I told you what the search warrant said yesterday. Without even reading it, I told you what it said. I was right. I knew what it said without reading it because it's entirely predictable. It told you nothing. I knew it was going to tell you nothing. It did in fact tell you nothing, but now we have a stream about it. Wicked v. Filburn plushies? What are we going to do? Like stalks of wheat or something as a plushie? I'm not sure what a Wicked v. Filburn plushie would be exactly, but I like your thinking. Plushies for famous Supreme Court cases? Heart of Atlanta Motel of the plushie? I don't know, man. We could have what is it? We could have what is the what's the train car case with the racism? It's why am I having a moment here? Plessy versus Ferguson. That's right. We could have Plessy versus Ferguson plushies. We could have a train car plushie versus Ferguson plushie. This is the worst idea ever. Worst idea. Segregated train car plushie. That's a horrible idea. Citizen United plushie. There you go. What would this plushies be for the slaughterhouse cases? I guess it would be a pig. Because that was, the slaughterhouse cases. The slaughterhouse cases were named for actual slaughterhouses. I mean, that's where they started. So why not, we'll just make a pig. We'll call him Oinky. The slaughterhouse case Oinky, the slaughterhouse case mascot. It all starts with pigs in a farm, man. It all starts with pigs in a farm. A plush pot leaf. We'll get a plush pot leaf and we'll call it a Reich. The Reich pot leaf. The only pot leaf that you're allowed to buy. What are my thoughts on the warrant being violating overbreath doctrine? No, not a chance. This is particular enough. Any documents that bear the seal in any container they're in, and any containers nearby, yeah, it's particular enough. Overbreath, not a chance. Cargo pilot guy 499. Feels like our republic is dying. We no longer value self-government, small government, and liberty. This is too much fun. Ask me more questions. Call him 5 for Slaughterhouse 5. Kurt Vonnegut. That's like one joke too many, maybe. What's the worst amendment? The 18th, man. Man, that's easy. Is sharing top secret military defense information with foreign countries considered a serious crime? If you're the president of the United States, no. No. If you're the president of the United States, no. You can. You can share top secret military information with a foreign government, and it might very well be prudent for you to, depending on the circumstances. So, if you're the president of the United States, is it sharing? No. So, yeah, you have to ask questions that you wouldn't normally ask. Of course, he's not the president anymore, but he might declassify the information, at which point, if it's declassified, he can share it with anyone he wants, so things become complicated. Cool Spring says, Kurt is happy and laughing. I'm in a very good mood, thank you. The 26th Amendment is the worst. The 26th Amendment is the one lowering the voting age to 18. What do you have against 18-year-olds voting? Can your son share that info? If it's in the clear, yes. If not, no. It depends how my son get it in the first place. Right? So if it's in the clear, then sure, anyone can share the information. Batman versus Commissioner plushies. I mean, okay, Batman is just totally a state actor. You guys know that, right? So we've discussed this before, right? All right, so yeah, this is your basic print. So yeah, we can have the Batman discussion again because that's always fun, right? Batman is totally a state actor. All that evidence is getting thrown out in court. All that evidence is getting thrown out in court against all these people. Joker, everyone, right? Okay, so normally, of course, the Constitution doesn't apply to a private actor. So you might say to yourself, oh, the Batman is a private actor. Right? So we don't have to worry about the 4th Amendment when it comes to the Batman. But is the Batman a private actor? Hell no. We got the bat phone. You got the bat signal. You know, he's meeting the commissioner on rooftops and shit. The Batman is not a private actor. The Batman is absolutely a state actor. He is so intertwined with governmental action. He's a state actor. So yeah, I'm sorry. All that he's a private official bullshit. No, he's not. He's a state actor. So now he's subject to the 4th Amendment. And he violates the Constitution all the time. Excessive force. He doesn't Mirandize people. You know, he takes them out of one jurisdiction and brings them to another jurisdiction without proper extradition process. Man, all these cases against all these people are getting thrown out of court. And also, we can't subpoena the Batman. We can't get him to testify. You know, all this information is getting thrown out. The Batman is a menace to the criminal justice system, man. He's no help to anybody. Batman is technically a criminal. I don't know if he is or not. See, that's the problem, right? Because we got the bat signal and we got the bat phone. You got the police commissioner calling up the Batman and giving him the bat signal. So you basically got the commissioner deputizing him. So I'm not sure he is a criminal because the commissioner apparently is deputizing him and authorizing him to conduct stuff in the name of the state. So I don't even know if the Batman's a criminal or not. This whole thing is messed up, man. How can a citizen bring charges against a politician without going through law enforcement? You can't. Yeah, I don't think there's many places left where they have citizens able to prosecute. I think Virginia used to have it, but I think they took it away. Batman has qualified immunity? For a 1983 thing, yeah, but the problem is qualified immunity doesn't help you on a suppression issue. So if you try to sue the Batman, yeah, you have qualified immunity issues. But then again, you've got, first of all, you can sue both the Batman and the Commissioner and the city of Gotham for the 1983 violations. And of course, because of the Bat phone and the Bat signal and all the rest, you got a pattern and practice from the city of authorizing all this. So the city is also liable for all that 1983 shit. Like, so we can get past the issues of there not being a respondeat superior because we've got enough independent action from the city authorizing this as part of a pattern of practice, either knowingly or willfully, blindly, take your pick either way, to be able to sue them. So we can get past that. We can sue the Commissioner, we can sue the city, we can sue the Batman for all the kind of 1983 violations. So yeah, but qualified immunity, yeah, but a lot of stuff is not going to work on qualified immunity grounds. Even if we can get past all the qualified immunity stuff, we got problems out the ass on the Fourth Amendment suppression. Because, like, a lot of stuff isn't coming in. $100 from Jeremy Duke. That is a very generous super chat, sir. Thank you very much for your hyper generous super chat. What are my views on blue flag laws? I don't know what a blue flag law is. I know what a red flag law is. Is a blue flag law some sort of law where I'm trying to flag politicians as, like, bad or something? I don't know what a blue flag law is, but I'm interested and intrigued by your idea. Thank you for your super chat, sir. Cargo pilot guy gave $4.99. Feels like our republic is dying. We no longer value self-government, small government, and liberty. Maybe. What is the long-term effects of Texas's law allowing private citizens to sue? Is that still a thing? I'm not sure if that's still a thing or not. And it doesn't matter anyway, because now the state can regulate it directly. So what's the point? So is that still a thing? I don't even know if that's still a thing anymore. Cargo pilot guy gave me $4.99. The 26th is the worst one because we abandoned the concept of limited democracy. It shouldn't be limited by race or sex, but it should still be limited to 21-year-olds and up. Okay, I mean, that's a position. Thank you for sharing. Would Lex Luthor and LexCorp have filed an amicus brief in Kelo versus City of New London? Are we trying to use, like, Superman? Superman as a state agent is harder in that universe. Because I don't know there's any government official directing Superman. Where are we doing the eminent domain thing from? How's that working? It's the same thing as a red flag law, but for mental health reasons? Is there any evidence they were declassified aside from hopes and dreams? No, there is not. And I've never made a claim that they are in fact declassified. I've only said that we have to ask questions that we normally wouldn't have to ask. There is no evidence at this time that they have in fact been declassified. I mean, I suppose other than the fact that they were physically transported to Mar-a-Lago, which I suppose could be viewed as perhaps evidence of declassification in fact by deed. But no, we don't have any direct evidence. Like, we don't have a memo or a directive or anything like that that would help us. But I've never made a claim that they are in fact declassified. I've simply said that we have to ask questions we wouldn't normally have to ask because the president, and it's complicated. So I mean, yeah. Premier says, I'm not talking as the effect of abortion law, but rather on citizens have standing to sue. Yeah, I mean, I was very concerned about that as well. Because it's like, what ability will this give citizens to sue in other contexts? And I don't know the answer to that question. I'm not sure anyone does. Captain Planet is definitely a state actor. How? He's conjured into existence by 5 children who are not acting under the auspices of state authority. Kash Patel says the president declassified in front of them. I mean, that's something. Thoughts on Ruby Ridge and Waco? Government done screwed up, man. What more can you say about that? Why the FBI sees the documents like clemency? I guess because it belongs in the National Archives, because it's a presidential record. I don't know. Term limits for members of Congress? I'm not sure term limits are a good idea. If I had my druthers for an amendment, I want to change the methodology of voting. I'd like to change the United States into some sort of preferential voting system. Prima gave 10 gifted Uncivil Law memberships. Well, thank you very much for giving 10 gifted memberships. That is very, very nice. And so many people are benefiting from your very nice gift. Thank you very much for helping to support Uncivil Law. It is super, super appreciated. Thank you. It's nice to see that's working. Ban said Patel will be the next head of the CIA. If he gets confirmed by the Senate, maybe. Explain the voting system. All right, so right now in the United States, we use what's called first past the post. So right now in the United States, when you vote for one person. So the problem with that is it drives inherently towards a two-party system, and so if you have the problem with first past the post is whoever gets the most votes wins, which sounds fair until you think about it, because it leads to a hypothetical possibility where if you have 10 people running for office, one of them can win as long as they get 11% of the vote, right? Assuming that all the other vote is split evenly. But right, so like if you have 10 people running and they all get 10% of the vote, they're in a 10-way tie. But if one of them gets 11% of the vote and the rest split the vote evenly, then you have someone winning the election with 11% of the vote. So even though 89% of people didn't vote for that person, they win. So this is a problem with preferential voting, it's a problem with first past the post voting. So it also drives people into a two-party system, because suppose you truly want to vote for a third party, but you know, of course, that it's very unlikely your third party is going to win. And so your vote is likely to be quote unquote wasted. Your vote, to the extent it has value, is more valuable in picking between one of the two winning candidates, right? So, and there's this idea that any vote that isn't for the first place, let me see if I get this right. Any vote that isn't for the second place winner is for the first place winner. So if you vote for the third place winner, you're really voting for the first place winner, because you're not voting for the second place winner, right? The only thing that you can do is vote for the second place winner, who might then become the first place winner, right? But any other vote is effectively a vote for the first place winner, because you're not making it more likely for a second place winner to win. So it drives you into this tactical voting. It drives you into a two-party system. And it leads to these weird complications. So what you want to do instead is you want to have some sort of preferential voting system. And there's a lot of different ways to go about this. Lots of different countries use different methodologies. There's two that are attractive. Well, there's three that's attractive, but one of them is too mathematically complex, and although it's the best, no one would ever buy it. So you could do some sort of concordant voting system, which does a whole bunch of pairwise calculations, but people then have to trust math, and so good luck with that, right? So since concordant voting is out, because I can't convince people to trust math, you instead can pick either approval voting or instant runoff voting, which is sometimes called single transferable vote. Single transferable vote is used in a lot of parliamentary elections. I know it's used in Australia, for example. So we'll discuss that since it's a more popular one. So what you do there in a single transferable vote is instead of voting for one, you vote for one or more in order of preference. So when you went to vote for president, for example, if you had 10 names, you could just vote for one of them like you did before. That'd be fine. But if you want to vote for more than one, you can. You just have to put them in rank order. So we'll just literally 1, 2, 3, 4, 5, 6, whatever it is, as many as you want in rank order preference, right? So now your vote expresses a more nuanced preference. And so basically what you do now is you take all the candidates, You take all the candidates and you count all their votes according to their first preference. So if you imagine this in paper, you can obviously do this electronically, but if you imagine it in paper, it's a little bit easier to conceptualize, right? So imagine a bunch of printed out ballots, right? And each ballot has a list of names, right, of the candidates who are running for that office. So what you do is you take all the ballots and you stack them according to the first name on the list, right? Because that's every voter's first preference, right? So if you have 10 people running, then you should have 10 stacks of names, right? These stacks of names, of course, are uneven, right? Because not everyone is voted evenly, right? Some people are more popular than other people, all right? So what you do is you take the ballots and you stack them according to the first person listed on the ballot, all right? Then you say, okay, do any of the candidates have a majority of the votes? If the answer to that question is no, which it probably is, then you take the stack that has the smallest number, right? You cross out the first name on the list, and now you redistribute those ballots according to now the top name on the list, which is now the second name, right? Does this make sense? So you take the candidate who has the least number of votes, you cross out the top line vote, and now you redistribute according to what is now the top listed name on all those ballots, right? So you put them into now 9 different stacks. Okay. And then you say, okay, do any of them have a majority? If not, what is the least one, right? Take all those ballots, strike the top name off the list, redistribute. And you keep doing that until you have a majority. It allows for a more nuanced voting preference. It allows for people to vote for a third-party candidate without this problem. Because, like, well, my third-party candidate is probably not going to win. So what I'll do is I'll put the person I really want first, where they're probably not going to win. But that's okay, because I'll put, one of the major party candidates second. Or, I have a couple third-party candidates that would be preferable. So I'm going to list 3 different third-party candidates, and in 4th position, I'm going to put the major party candidate, right? And so it allows for a more complex voting expression. And what's nice about it, right, is that it fully maintains one person, one vote. Because this is one of the objections I hear sometimes. This defies one person, one vote. No, it doesn't. Everyone has exactly as much vote, because every voter has exactly the same amount of voting power in every round, right? Every voter's vote is equal in every round, right? So if my vote is for the person who will ultimately win, then my vote never moves. But my vote counted the same as everyone else's vote did in every round, right? So whether or not your preference gets stricken or not, right, your vote has equal power in every round. So like on the first round, we're all distributed according to first preference, right? So we all have equal power, right? My candidate is still in the race. Your candidate is not. So your candidate's name gets stricken off the top of the ballot, but that's okay, because now we're on to round 2. Now we take a look at all the ballots. We could even like put them all back into the same pile if we like and redistribute them again. It'd be a little bit inefficient, but we could, right? So it's like, okay, let's just look at all the ballots and be like, okay, what's now the top name on the list? And like, okay, well, my ballot is still the same as it was before. Your ballot's changed, but we still have equal voting power. So it doesn't defy one person, one vote. Everyone has now just a more complex vote than they did before, but everyone's voting power is the same. So that is way more information than you wanted, I'm sure. But that's how single transferable voting or instant runoff voting is working. The alternative to that, by the way, if that's too complex for you, the alternative to that is just check every name that you like and then just see who has the most votes. Which leads to this situation where more than one candidate could have a majority of the votes, which is a little bit weird. Because if you say, okay, just vote for as many candidates as you like. This is called approval voting. No ranking. So you can check any number of the names you want. And now you're in a situation where it's like, okay, just count how many total votes there are for all the candidates, and whoever has the most votes wins. And this is approval voting because basically you wind up in a situation where it's like, well, what percentage of the voters approved of you? Right? And this could be any number between 0 and 100, hypothetically. And it's quite possible in this situation to have more than one person who has more than 50% of the vote. You just select the person who has the most. So you'd wind up in this situation where, like, person A for president has 86%, person B for president has 84%, person C for president has 73%, person D for president has 62%. Okay, person A wins because they had the most. You know, and that also works. But it's less detailed. It's less cumbersome. It's less cumbersome than instant runoff vote or single transferable vote because now you don't have to list preferences. And it's easier to count. It's just a little bit unsatisfying at the end because you wind up in this situation where multiple different candidates have more than 50% of the vote. And somehow people feel that that's unfair, even though it's totally not. It's completely fair because we're voting for the person who has the most votes. But single transferable vote or approval voting, or you can do concordant voting, which is where the math comes in and no one likes it. Which I don't want to explain because it's going to take too much time and it involves math. But yeah. It also, incidentally, would help a lot in the primaries because it would tend to the overall trend of either system is it would lead to more moderate candidates. Because either way, you're voting for people that more people would approve of. So it tends to vote for more moderated candidates on the whole, and it tends to lead to more accurate representation of what the voters want. The ultimate problem, of course, is it comes at the expense of the two-party system. So you can never get the Congress to vote for it because you're getting them to vote for a system that would threaten their power. So yeah, you can never get them to do that. What about MMP? MMP is not good. MMP is a multi-member party, multi-member districts, right? So you have more than one representative per district. That defies U.S. principles too much. So if you're talking about something like MMP, no, that's too big a change for the United States. I don't think we want to do something that's going to change the one person per district principle. Do I plan on writing a book for constitutional law laypersons? Maybe someday. Do I support abolishing the Electoral College? Not really. Where does the Electoral College come in? Oh, in my system? It doesn't necessarily. It's going to be much more impactful on the representatives and senators than it would on president. But at least in principle, it doesn't do anything to impact the Electoral College. It would still be like winner takes all from each state. You just have a more nuanced view of who that is. It would lead to more nuanced things. It doesn't inherently do anything with the Electoral College. Yeah. Maine was also experimenting with instant runoff voting. I think it got struck down by their Supreme Court, though, unfortunately, which really sucked. All right, I'm going to sign off for now. I've been enjoying the stream. We might still be on later today with more. But yeah, the search warrant was a non-starter. There was nothing. I thought this was going to be a 10-minute stream. I really did. When I started this, I thought there was going to be a 10, 15-minute stream. Well, that was a long time ago. What happened, man? I had plans. Oh, well. I guess we got wrapped up. We got wrapped up talking about law, and it made me all happy. See what you guys made me do? You guys made me talk about law, and it made me happy. Urgh. MMP is 2 votes, a local MP and a party vote. Assign the MPs first, then split the parliament according to party vote. That is a horrible idea. Voting for parties, at least from the American conception, voting for parties rather than people, no thank you. That's okay. That's fine. No, I'm going to take a hard pass on that. But thank you for your contribution. Yeah. If you've been enjoying the stream, please remember to do all the YouTubey things, like, comment, subscribe, hit the subscribe button if it's red. Thank you again very much to Jeremy Duke for the $100 super chat. That was incredibly generous. I appreciate it. Vote Kurt Mueller. Vote Kurt Mueller to be the head of the convention estates. Maybe I can get them to vote for my crazy a crazy election proposal that will fix everything. I've been Uncivil Law. Until later, my friends, I hope all's well. Cheers, my hands. And goodbye.